Hi, everyone. I'm Mrs. Cozen, and I'm here with Mrs. Record. We're the media specialist from Parsippany High School, and we're going to present today on intellectual property, copyright, and fair use.
Okay, we're going to go over, first of all, the four types of intellectual property, and we're mostly going to focus on copyright because that's the thing that you're going to be most concerned about. So there's four types of intellectual property: patents, trade secrets, trademarks, and copyright. We'll just go over them briefly. A patent is a limited duration property, right, that relates to an invention, and it lasts for 14 to 20 years. It depends on the type of the patent. And for something to be patented, it has to be novel and not obvious. So nobody has come up with the idea before, and it's an unexpected or a surprising development. There's three different types of patents. A utility patent, and these are the most common. They're granted to new machines, chemicals, processes. Usually drugs fall under these type of patents. A design patent, and that's granted to protect the unique appearance or design of objects, or a design of ornamentation. So there's an example below. On the left-hand side was a design patent put out by Nike for a shoe with the little shock absorbers in the heel. Nike patented the design, and then Walmart made their own shoe and was selling it in stores. Nike sued Walmart for patent infringement. Nike did win the case, and Walmart had to stop selling this shoe. And then the final type of patent is for a plant, and this is for the invention and reproduction of a new plant variety. So think about the different types of fruits and vegetables that you eat. These kind of things are patented under plant patents. All right, another type of intellectual property is a trade secret. So trade secrets do not have to be registered with anyone. They're things that companies keep to themselves. They don't put it out there and publish it because they want to keep it a secret. So think of things like the Coca-Cola formula, the KFC recipe, the WD-40 recipe, and then even Google. The algorithm for how they present their search results is a trade secret. And another type of intellectual property is a trademark, and these are things you see out there, like brand names, logos, colors can be trademarks. They're words, phrases, symbols, or designs that identify and distinguish the source of good from one person to another. The Tiffany box picture that you see there, the trademark is actually the color, that Tiffany blue color, their logo, and the actual box is a trademark to Tiffany. All right, so those are the types of intellectual property. We're going to learn mostly here about copyright. So now we're going to look at a little video explaining copyright, and then we'll talk a little bit more about that.
Whether you're a local artist composing your own music or a massive studio filming the next blockbuster, all creators should understand how copyright, public domain, and fair use affect their work. Although these legal concepts can be somewhat confusing, we're here to break things down into easily understood language. Keep in mind that this video should not be taken as legal advice. Also, we'll be focusing on copyright in the United States. Copyright is the concept that original works, such as writing, photos, or music, belong to the people who create them, and that you cannot use, copy, modify, or publish that work without permission. If you violate copyright, it's called copyright infringement, and you may face steep consequences, such as lawsuits or criminal charges. The vast majority of movies, music, books, photos, and other types of popular media are protected by copyright. Generally, those copyrights last for the lifetime of the creator, plus 70 years after their death. However, the duration of a copyright can vary due to its publication date and ever-changing copyright laws. When a work has no copyright protection, it enters the public domain. Content in the public domain can be used, modified, and published without permission or restriction. This includes all works published prior to 1923, as well as works with expired copyrights. Creators can also place their content in the public domain if they desire. Although you normally need permission to use copyrighted material in your own work, there is an exception called fair use. Fair use allows you to use brief portions of copyrighted works without permission for certain types of use, such as criticism, teaching, or news reporting. However, fair use can get tricky. For instance, you may not be able to claim fair use if you use the copyrighted work for a commercial purpose or take too much of it. When in doubt, always respect the creator's copyright and use as much of your own material as possible to avoid issues. Although copyright, public domain, and fair use can seem like giant, complicated subjects, you should now have a better understanding of the basics.
So again, to recap, copyright protects things like artistic works, paintings, photographs, sculpture, music, movies, videos, live performances, believe it or not, literary works such as poetry, essays, novels, and scripts, and code. So video games and software code, those are things are protected by copyright. So something is protected by copyright the moment it is created in physical form. So that means the moment it's posted to a blog, the moment that something is put on the internet, the moment the photo is taken. And you do not have to register your creation in order for you to bring about legal action. And like the video said, the copyright lasts for the life of the author plus 70 years and sometimes longer. And if you want to read that in more detail, I posted a link to the Copyright Office on the bottom of this screen. So therefore, you should assume that every work is protected by copyright unless you can establish that it's not. So do not rely on this symbol to make the determination that it is copyright protected or not. It is copyright protected unless you can determine that it is not. So works that are not protected by copyright. So copyright must be the result of some creative effort. So not protected are ideas or facts. So scientific facts, historical events, biographical information, the news of the day, that's not protected. Lists or methods, so recipes are not protected. Titles, brand names, or slogans, those are protected under trademark. And government documents, so photos, artwork, and reports, things that you the Library of Congress, the government archives, or any .gov website, those are not protected by copyright. So public domain, if a work is not copyrighted or its copyright has expired, it enters into what's called the public domain. So when a work is no longer protected, it becomes part of that public domain. Things like Shakespeare, the character Sherlock Holmes, they are no longer protected. So you can take the character Sherlock Holmes and write a different book about Sherlock using Sherlock Holmes as the character. Creative Commons, that's a place you can go to find things that are in the public domain. So music and images. So if you're creating an app and you want some background music or images, Creative Commons is a good place to go to find things that are in the public domain. If you want to do a Google search, you can set your search so that the images you come up with are not rights protected. So let's do a Google search for dogs, let's say. And right now, these are all of the images of dogs that come up. If I go to Tools and I go to Usage Rights, there are different usage rights here if I do labeled for reuse or labeled for non-commercial reuse. So by clicking on these, it will filter the Google images to things that are in the public domain. And you can use these without having to ask for permission.
Okay, so what do we want to be careful about? We want to be careful about violating somebody else's copyright. So the most frequent type of copyright violations are internet piracy. And what does that mean? That means uploading, downloading, distributing copyrighted material that you did not pay for, like music, movies, software, and video games. So you want to, I'm sure some of us have used things like YouTube to MP3 and copied a song and put it in our library. That is a copyright violation. Distributing copyrighted material even though you paid for it. So most of the things that you purchase are for personal use only. You're only authorized to view, listen to it for your own use unless it tells you otherwise. The things that we buy in the library for streaming and DVDs, for example, are specially authorized to be shown to an audience. Netflix is also protected this way. At this time, it's only sold for personal use. So when it's actually shown in a classroom or in a club, that's a violation of the copyright. And what we want to look out for is, am I affecting the money that this artist would be making or the industry would be making? So internet privacy is got a big economic effect, not only on just the artist or the company, but also all the people that work on this video or this entertainment are being affected. So you have to think always, am I taking away money from the original artist? And let's talk about how likely is it that you will get caught. Some companies patrol the internet, and Walt Disney, McDonald's for infringement. Employees are common sources of infringement reports. So for example, I used to work for a big drug company, and we were told we made Advil, we made Robitussin, we made Centrum, and we were told if we were out in the store and we saw something that looked kind of like the Advil box, we were to bring it to the company and the attorneys, and then they would go after that that product that was out there. You never really know who's in your classroom. Parents work for different companies, so just be careful of doing something that kind of is out there. New technology makes it possible for copyright owners to encode their music or photographs with digital tags that make it easy to track. So YouTubers, I don't know if you've ever been heard of being copyrighted. A lot of YouTubers are sometimes using copyrighted material on their channel, and then they have to have it taken down. So the more traffic, the more things that people's eyes on the thing that you are using, is a bigger chance of it getting caught. So if you put up a YouTube video and then your YouTube video becomes more popular than the original artist, the chances are that it's going to be flagged. So should I just ask permission or just put a citation? There's a myth. It's okay to use something as long as I just cite it. This is not true. And sometimes the acknowledgments can backfire because you're bringing attention to it and then create additional claims against the copyright. So when you're in doubt, just seek permission of the owner. Mrs. Kozin and I have asked people to if we can use their work, and we've actually had people ask us if they can use our work, and it always is very simple email, and usually the person will get right back to you. Don't always use a disclaimer saying this work is associated. It might help, but it might make it worse because then you're pointing out that you used the work in the first place.
All right, so fair use. So you may have heard that if I'm using this for educational purposes, well, it's okay. I can use whatever I want. It's for educational purposes. Well, that's not necessarily true. Sometimes it is, but not necessarily. So there is a fair use doctrine associated with copyright law, and fair use recognizes that society can benefit from the unauthorized use of copyrighted materials, and it is for these three categories. So commentary or news reporting, criticism, so analysis or parody, and finally teaching and scholarship. So let's talk about what is fair use. There are 4 factors of fair use. The first one is purpose. So what is the intended use of the alleged copyright material? So you want to take someone else's thing and you want to claim fair use. Well, what is your intention? What are you using it for? Are you using it for commercial purposes, educational purposes? Is it nonprofit? Is it going to benefit someone? And are you transforming this original work into, are you making some markedly different change? Are you changing the whole meaning and purpose of it to make it something that's your own? Or are you simply creating a just glorified imitation of it? If your work is transformative, then that's better. That will more likely result in it being fair use. And the second factor is the nature. So what is the nature of the original work you're taking? Was it published? Was it unpublished? Is it more creative? Is it factual? And third is the amount. How much of the original work are you using? So this is tricky. There's not a set amount, and usually it's a judge may decide if it comes to court. It may decide is the amount is based on how much of the original work is needed to maintain its essence. And finally, impact. So what is the economic impact of using the material? Does it impact the ability of the original creator to make money? So are you taking, by you taking this, are you taking away money from the original creator? So let's look at some examples. Okay, this is an example of what originally started out as a photograph. So during the 2008 presidential campaign, the artist, he's a graphic designer, Shepard Fairey, took a copy of a photograph that was taken by the Associated Press of Barack Obama. So Fairey, the artist, made it into a mixed media street poster of the photograph, and he added the word hope. So it was originally a campaign poster, but ultimately it went viral. And it was used to sell a lot of items. So it made it onto mugs and postcards. And this is kind of an example of when something becomes so popular, it gets noticed. So now the AP, the Associated Press, claimed that this is a copyright infringement. You took our photo, and it's basically a copy of our photo. So who do you think was favored in this instance, and why do you think that? So when this goes to court, the judge will consider the 4 factors of fair use. And like I said, it's commonly believed that if you make 5 changes, 6 changes, that that automatically makes it a different piece. You've automatically transformed this piece into something else, but that's not necessarily true. A judge will decide whether you have transformed the original work, into something originally your original creation, or have you just made a copy of it? Just a glorified copy of it. So in this case, so it did go to court, but the judge never had to rule on it. The artist, Shepard Fairey, eventually settled, and he paid an undisclosed amount to the AP, and he agreed never to use another one of the AP's photographs again in his work. So, while it never went to court, I guess the artist conceded, well, maybe. And just in case you're wondering, we said government property is part of the public domain, but this was not government property. The AP is not a government organization. It is a press organization. So in case you were wondering that.
I think in this example, sorry, Ms. Kozin, while the poster is different than the photo, it really just, the poster just kind of copied the essence of the photo. So the coloring, the pensive look is pretty much identical. The head tilt's a little different, but the spirit, I think you referred to that before, the spirit and the essence of the work is what really is too close here.
Right. And I guess the artist thought maybe the judge would decide that too. So I think he decided to just, play nice and make everything a little bit easier, and he decided to settle. So this one's a fun one. This is Dr. Seuss Enterprises versus Comic Mix. And so Comic Mix is the defendants were, so the Comic Mix is a fan fiction website, and they were the defendants in this case. So what they did was They combined elements of Dr. Seuss's Oh, the Places You'll Go. I'm sure you remember that children's book, and the sci-fi franchise Star Trek. And so instead of Oh, the Places You'll Go, it's Oh, the Places You'll Boldly Go. And I don't know much about Star Trek, but I think the word boldly is, well, we'll see. So Dr. Seuss sued Comic Mix for copyright infringement. And here's what happened. So the judge ruled that the word boldly made the work highly transformative. So combining Oh, the Places You'll Go with boldly, which I guess is very indicative of Star Trek. So the judge said that made this work highly transformative. It made it just this mashup of these two things that, was neither one or the other. And also that it didn't deprive the Seuss Enterprises of any revenue, maybe because two different types of readership. The excessive copying was another element that kind of worked in the defendant's favor, because they said, yeah, of course we copied exactly how you couldn't understand it unless we copied the font and the hash marks. That's what makes it a mashup. So ultimately the favor was for fair use, and Seuss Enterprises apparently thought this was a terrible ruling. And so they are appealing. And I think something happened in November where they had to file papers. So this is something that is still being watched. And you can read about the case right here. I provided a link, and I'll provide a link at the end of the presentation as well. So just in case you were wondering, because I know we talked about asking permission and citing works. So plagiarism versus copyright. So just to be clear, plagiarism is using someone else's words or ideas without giving them credit. So if you write a paper and you use someone else's ideas and you interweave them into your ideas, or you quote somebody, no, you do not need to ask them for permission. You just need to cite your source. Copyright infringement is a little bit different. So copyright is taking someone else's work without asking them permission and doing one of the following. So either performing it publicly or creating a derivative of it for public display. So maybe if you wrote like a different Harry Potter book and tried to publish it, that would be, or tried to distribute copies, that might be a copyright infringement. Or taking someone else's work and distributing copies without effectively applying the principles of fair use. So these are different things. At the end of this presentation, I've included a chart that talks about the differences. So finally, just to wrap up, your class is going to be probably creating applications or code, and these are things that you might want other people to use. You might want to one day sell them. So to avoid copyright violation, it's simple. Find things to use in the public domain. Find things that are not copyright protected. If you find something that you absolutely have to use that is copyright protected, ask permission and cite the source. And consider the 4 factors of fair use. So make a case for fair use before you use someone else's work. So when you're taking it, consider if someone were to come to me and say, hey, you violated copyright, what's your defense going to be? So do that first before you use someone else's copyrighted work. And so finally, there are some resources at the end, and we're going to post this presentation so you can refer to it. There are some questions for you to answer in a Google form to see how well you understood what we said, and there are some little things for you to analyze and answer. So thank you so much.